I'm Ariana Tadler from Milberg, but also from Meta eDiscovery, and we are great users of Relativity. We love the platform, and have worked with the team for a very, very long time. Next to me, probably needs no introduction, is Judge Shira Shinlin. You'll probably recognize her name. She was from the Southern District of New York, a federal district court judge, and issued some of the most prominent opinions from the very beginning of the e-discovery law time, including, of course, the whole Zuba Lake series. And then next to the judge is Paul McVoy, who is my partner at Meta eDiscovery. He's the guy who does all the work and does so always with a smile on his face. So today, what we're going to be speaking to you about is the fact that you'll see that our slide actually says plaintiffs can use technology too. That's what we were booked to talk about. But we're going to switch that up just a little bit. And if you could, oh, I have the slides now. Apparently, I'm in charge. Okay, so we slashed that out because we wanted you to understand that it's not always plaintiffs who are requesting all the information, right? In any litigation, discovery is reciprocal. I can't think of a case that I have litigated over 25 years where I was a plaintiff's lawyer and my opponent didn't ask some kind of discovery. And I do mostly asymmetrical cases, so you can think about things like class actions and mass torts, where oftentimes the plaintiffs might be individuals, or even in an antitrust case, they could be small businesses. But the truth of the matter is, most litigation tends to be more commercial or one-to-one. But regardless of whether you're one-to-one or you're in asymmetrical litigation, there is going to be discovery going both ways. And I wonder, Judge, is that your similar experience that you find?
Absolutely. Many cases, both sides have a lot of discovery to exchange.
And so what we wanted to do is focus this on the received production, right? So it's about analyzing the documents that are coming in as opposed to documents going out. Typically that's plaintiffs, but not always.
And the other things that we want you to be thinking about is that if you are in asymmetrical litigation, of course, a plaintiff is generally not as well financed or financed at all personally, in contrast to if they are against a large corporation. That can also be true if you have a small business. They too may not have the same kind of funds to be allocated in their budget for litigation, and yet the litigation might be a make or break situation for that company. So we want you to be thinking about that. And then we'll also be talking about the fact that when you receive a production, so we're talking about requesting parties, when you receive a production, what you do with it in the context of e-discovery is very different than if you are a producing party, because you're starting at a much deeper level of the sort of life cycle of what we think about from e-discovery. Not to say that a requesting party doesn't have to gather information and sometimes process it, but there's much less of that when you're in asymmetrical litigation. And so we'll be talking about how you can use some of the tools as we go.
So if you haven't downloaded your app,
right.
It's probably
Now's
too late.
the time to do it, because you don't want to miss lunch. We've already spoken about who we are, but we are going to be giving you three distinct perspectives, but of course they interface because we interact together throughout the course of a litigation. We'll be talking about the lawyer's perspective. What is our goal as lawyers in the context of discovery? And again, drilling down a little bit more deeply about when you're a requesting party, how are you approaching that part of the life cycle? We're also going to talk about the technologist and what are the goals that the technologist has in terms of what is the specific objective that's given to the technologist. And so what are the goals that the technologist has? What are the expectations of the lawyers who hired the technologist? What does he or she have? And then also, of course, talking about what is the judge's perspective, and to what extent is the judge positioned appropriately to make decisions in the context of discovery when there is a dispute? And is it always when there's a dispute, or is there sometimes some dialogue with the judge early on, right? As you know, especially in the federal system, there's been a big movement under the federal civil rules to have much greater, more active judicial management. And so we see early on from 26F meet and confer conferences and Rule 16B conferences where we're involving the court, and we're either telling the court what we plan to do, or if we feel like there's already tension, we may be asking for some guidance and finding out, what does the judge feel about that early on and then also later in the cycle. And again, when we're talking about technology here today, we are mostly going to be talking about technology-assisted review, the use of analytics, et cetera, although, as I said, we're very accustomed to using the platform here for a whole host of reasons. So we just wanted to throw up for you what are the challenges that requesting parties find when they're considering and when they actually do adopt the use of technology-assisted review, especially in asymmetrical cases where you have, again, a smaller plaintiff and a larger entity on the other side. The use of TAR is fairly new in terms of a more universal application, and it's not universal at all. There's still really a select group of people who are using technology-assisted review on the requesting party side for a variety of reasons. What are the challenges? So we have them here, right? Understanding your options. A lot of plaintiffs and even their lawyers, to the extent that they represent smaller groups or individuals, they often don't even know what the options are. And for those of you who've been coming to FEST for a long time, it's a pretty big learning curve, right? I mean, think about where we were back in the day when we were just talking about, quote, predictive coding. Then we started talking about TAR. Now we talk about TAR 1.0, TAR 2.0, CAL, all of those things. Well, if you didn't grow up in the world of technology in terms of your job, that could be as a lawyer. That could just be by reason of where you are, as I say, seasonally or generationally in your life cycle, for those of us who've been around for a while. Trying to understand the options when suddenly they're thrown at you on a menu, if you didn't understand the first early series, it's a little difficult to catch up unless you're working with really educated and experienced people. Cost, of course, is always a concern. One of the things that most people don't realize is that litigants in asymmetrical cases, and doesn't always have to be asymmetrical, but there are lots of cases where lawyers are working contingently. So in a class action or a mass tort, by way of example, or personal injury case, lawyers generally are working contingently, which means they're not getting paid unless they win or successfully settle the case. And in addition, those lawyers are advancing the costs of all of the litigation. So when you think about the use of the tools that you all are so accustomed to using, and they might be there at the point on your desktop or on your tablet, for dealing with requesting parties, oftentimes these are things that they have to go out, they have to spend some money. It's not the client's money as of yet, it's actually the lawyer's money. And so if they're not really educated, they're taking a big risk in suddenly writing a check or putting yourself on automatic payment for a tool that you're not that familiar with. Technical know-how. I've already talked a little bit about that there are a lot of lawyers out there that don't know how to use the tools, and they're not even sure how to go out and ask necessarily for help because they're a little bit overwhelmed with the tools. Well, Paul and I hope that we've solved that for a lot of people by coming into the market.
And that one also, the technical know-how keeps people from even engaging in the conversation because they don't know the questions to start asking. And so one of the things that we always advocate is just call someone who's done it before and use the technology, because then you can start talking to them about what they can do, the options that they have, and goes back up that chain to educate them a little bit, tell them their options, and then explain the cost difference. Because when a plaintiff is deciding to write a check for $10,000, that's a major decision for them to do and to engage in that kind of conversation. But if you put out the use case in the scenario where they're not going to have to use all of their associates to review documents, which 10% of them are only going to be the ones they want anyway, it's a good way to get to that solution.
Yeah, the other thing that we've done is when we hear about law firms that really don't have great exposure to some of the tools, we'll just say, do you mind if we come and do a lunch and learn? Our dime, but we're happy to pay for lunch too, just to come and visit with you and talk to you about what's happening in the market so that you can think about what really is the best way for you to win your case. There's nothing worse than being in a situation where you're in an asymmetrical case, you're working hard, you get yourself through the motion to dismiss, discovery may have started, but the bulk of discovery tends to come after the motion to dismiss is resolved in many cases. And at that point, of course, you're issuing these document requests and asking for all sorts of things, and suddenly you get the data dump. Defense counsel calls you up and says, hi, we're about to produce, 2 million pages. Well, the first reaction often is, 2 million pages, what are we going to do with that and where are we going to put it? But there's so much more to the discussion and the thought process, because it's not just about where you're going to put it, it's what are you going to do with it? How are you going to get through it? What kind of deadlines has a judge like Judge Shinlin put you on? I actually had the privilege of litigating before Judge Shinlin. I had a very, very large case that went on for 10 years. But even though it was a 10-year case, she had us on the equivalent of a rocket docket at times, where she had deadlines and said, you're going to hit this deadline. I'm not moving this deadline. So if you end up in a case where a data dump suddenly happens and you're facing a deadline for close of discovery, having to identify experts, for example, for class certification, for summary judgment, you have to have some kind of mechanism that is very, very distinct than linear review with people sitting around a bunch of computers and reading them and manually just coding them. That's not going to get you to goal. It's just impossible today. I think probably a number of years ago when Paul and I first met, there were still people who could do manual review in some cases. It would take them a little bit longer. But now it's just not realistic. Can you think of any example where it would be?
So we see in smaller cases where people try to get through the documents by themselves or with a team. And that can kind of work if you have 5,000 documents or so. But we're really seeing the teams now that are engaging on the receiving party using technology-assisted review to kind of stage their review. So they might not skip documents from review altogether, but they might put the more important ones up front and leverage it like that. But no, I'm not seeing anyone that's going to skip just doing manual review on the larger cases. It's just impossible.
Can I interrupt the conversation
Of course.
just for a minute to find out who we're speaking to? I'm sort of curious. It's a very small group. There's only about 25 of you. So how many of you are typically requesting parties, plaintiffs' lawyers? Please keep them up for a minute. About 3 of you are plaintiffs' lawyers. How many of you are practicing defense-side lawyers? Again, only 2 or 3. What are the rest of you? How many of you are in the technology business? About 7. Thank you. That was helpful for me to sort of know the audience we're addressing. The reason I ask that is, as a judge in the federal court for a long time, I'm aware of the tremendous range of cases that come to the courts. And I was only in federal court, but then you think about state courts in 50 states, and what's going on in all those courts and all those cases. So I think that you're speaking about a bit of a rarefied world. There are small cases. There are hundreds of thousands of small cases there in state courts, and even in federal courts where this issue isn't even alive. But I think we are focusing on those cases that have a critical mass of discovery. And that's where the gold is. The cases don't go to trial anymore. In federal court, about 2% of cases go to trial. In state courts, 1% of cases go to trial. So how do those cases get resolved? They get resolved because people get a lot of discovery. They find out what there is to find out, and they either settle it or it's decided on motion. But it's not a trial. So discovery is where it's at. And in a case that has a reasonable amount of discovery, you're in the wrong place if you don't understand the technology that these 2 experts are really talking about at this panel. I say these 2 because the judges that you're before, at least for another 20 years, are going to be older than the practitioners before them. That will eventually equal out. You talked about the generation gap, but a lot of the judges that your case is in front of, and I realize a lot of you are not practicing lawyers, you're on the technology side, but you're helping lawyers, and the judges that there before will not have a sophisticated understanding of this, even though there are all these good seminars out here. Most state courts can't afford judicial education. The federal courts are busy with lots of other things, like criminal work and terrorism, God knows what, so they really can't train themselves on this. So it becomes your job to explain these options and how they work and why they're beneficial. Now I'll be quiet again so you can go back to learning about technology, but I just wanted to set the stage of
I
the,
have
of the
a
bigger
question.
picture.
I
Sure.
have a question
sure,
for you.
Sure.
So I'm not a lawyer, never gone to law school, but I'm frequently now going to hearings and speaking
Good.
to the judges.
Great.
What's your opinion on that?
I think it's absolutely spectacular, and I used to encourage that. I would say, can you please bring somebody to my courtroom who can explain this to me? The lawyers don't really get it. I ask them questions, and they say, well, I'll have to get back to you. I have to check with so-and-so. I don't have the answers today, and that's not satisfying to a judge. The judge doesn't want to wait 2 weeks for an answer. You want an answer on the spot. So I would often say, can you bring your expert? Can you bring your vendor? Can you bring somebody with you who has an answer to my questions? Because the worst thing I would always hear is, we can't do it, it's too expensive. And I would say, well, what does can't mean and what does expensive mean? Those are relative words. This case, is a $1 billion case, or this case is a $500 million case. What does expensive mean? What does can't mean? And what does it would take months mean? And so unless somebody can answer those questions, it's not helpful. And then the other side would say, that's not accurate. My vendor says it can be done in 4 weeks. And the other side is telling me 4 months. What do I know? So you do need to have people there who can explain.
And in that kind of situation, you really are being asked to make a judgment call
Oh, yeah.
because one side is saying X and the other is saying Y.
Right.
And especially when it comes to the cost component, right?
Absolutely right. And I want to say, and I hope it doesn't come off as immodest, I actually had some understanding of all this. The vast majority had even less understanding than I did. And so they're really starting from not square one, but negative square 5. And so you have to give them basic training for 15 minutes before they can even then take the next step of helping decide if there's a dispute, what's going to be permitted and what's not. And we'll get into some of the details of that as we move
Right.
along.
Right. So just, running down again, the list of challenges, the fear of missing something. Surely, if you're a producing party, you have a fear that if you've used a tool and you haven't done a linear review, that you're risking sending over the bow something that is privileged, something that is actually non-responsive or irrelevant in that case. But while you might think in the first instance, well, what's the big deal? The big deal could be that it's opening your client up to some other risk of litigation or some kind of liability that they hadn't thought about. But we're also, again, in a world where linear manual review is just not realistic. There's just too much volume in these big cases. And again, they don't have to be asymmetrical cases. You think about an Apple versus Samsung, right? Especially the patent cases where these big companies are fighting over who owns what IP or who stole what IP. Now it's big gun against big gun. So the cost component actually can be eradicated from that equation, although there still is this concept of course, under the federal rules, we talk about what's the scope of discovery, both proportionality and relevance. And just because you're two big guns against one another doesn't mean that you're not going to be talking about what is proportional and what's relevant.
I want to add one more point. There's a new player in the arena that wasn't there 5 or 10 years ago, and that is litigation funders. So we don't always have the asymmetry we once had, because even smaller plaintiffs can be funded and can play in the arena with the bigger players. So both sides are prepared to spend the money that it takes to get the discovery, to get to the bottom of the case and get it settled. So I think that you should be aware that there's money to be spent and parties will spend it in the cases that warrant it.
But that's an issue that I could spend probably 4 hours on because of the fact that, again, if you are a firm that has taken a case on contingency, even if you've taken advantage of some kind of litigation funding, the fact of the matter is you're still on the hook, right, for those dollars. You're advancing those dollars, but now through a litigation funder, and interest is accruing. So it's, if for somebody who is concerned about cost, it's actually a double whammy, because there's, in essence, a multiplier on what those dollars are costing you.
Well, certainly it encourages efficiency.
Yes.
Your dollars are at risk, but so are the funder's dollars. And the
Yes.
funder is aware of technology, and they factor it into their decision to fund. How much is this going to cost? It's one of the things they assess. But they're taking on risk too, but I'm not here to debate that. I only want to say everybody has the ability to use the tools to be efficient.
So then, and then there's judicial management. So you've already determined, no doubt from this conversation, Judge Shinlin was a very active judge. Certainly in the litigation that I had, she had an expectation of seeing us very, very regularly. And if she wasn't seeing us, she was at least speaking to us on the phone, even if only for us to say, no disputes this month. That is what the federal rules and some of the other state rules that have evolved over time are looking to impress upon people. But there are lots of judges that are not active judges.
But then if they're not proactive, they're reactive. So it's true that some judges really understand case management and will get involved early on in getting these disputes on the table and worked out so we don't have to worry about do-overs if it's done wrong. But I would encourage you to say that even if it's not a proactive judge, if you see a dispute, it is much better to bring it to the court and get it resolved than to go off on your own unilaterally and say, well, this is the way I'm going to do it, and it's just too bad for you. Then the other side complains after the production, and then the judge is faced with the issue of whether to order a do-over. And there's a whole lot of cases about whether or not the court will say, you did it wrong, you have to do it all over again, and I don't care about the cost, you should have come to me earlier. So I would say if you have disputes, bring them to the court.
And what we see frequently in the field is the parties will negotiate for a month or for 2 months or for 3 months and not ever be able to come to some kind of agreement and then hobble together something. Would you recommend at the end of the first month where there's no progress being made, just to bring the issue to the court and get it done?
I would say early involvement by the court is always good, because otherwise the court's doing it from the back end, looking back at what you did and judging it and assessing it and worrying about sanctions, and I already said sanctions or do-overs. And the court doesn't want to be doing that. So I think they'd rather you come in earlier. And again, some courts, as judicial case management, will schedule conferences regularly. So that's the proactive type. But I would say, if I were guessing, most judges are reactive, not proactive, only because there's no time. They have very, very huge dockets. State court dockets are 3 times what federal court dockets are. So they don't have time to be proactive.
And one last thing on it, what about the fear that they're annoying the judge and the judge is going to then later rule against you on something more substantive?
No, I don't think so. I mean, judges don't love discovery disputes. There's no doubt about that. But I still say they're going to have them on the back end. They'd rather have them on the front end. So I wouldn't worry about, quote, annoying the judge. If federal judges have the great advantage of having magistrate judges in their court. So a lot of district judges don't want to deal with this at all and won't. They send it all to the magistrate judges. So for those of you who read all these opinions in this area, they're overwhelmingly written by magistrate judges. 80% of the opinions in e-discovery are magistrate opinions. And you can always ask, if you sense a district judge is unhappy, just say, Judge, we would be very happy if you refer this case to the magistrate judge. And I think the judge would say, phew, good, go away. But the state courts don't have that benefit. And the best you can get there, if it's a big enough case and you can afford it, is we would like a special master appointed. We understand, Judge, how busy you are. We both think a special master would be helpful. So you can request that. There's nothing wrong with saying to a state court judge, would you appoint somebody who can supervise this? And in big cases, they do.
And oftentimes, too, that's where you want to bring somebody from the technology side to the table, right? Because you want to constantly be educating the judge. And I have to say, as somebody who's been litigating for as long as I have, I've actually just recently swung the pendulum in my head in a different way. I used to always think, well, I don't want to annoy or frustrate that judge. I don't want to bore that judge. I don't want to give that judge so much detail that the judge actually, his eyes or her eyes glaze over, and now It's, I don't have the attention or the scope that I was looking for. Now I look at it very differently. And I should have looked at it, I think, this way all along, but when you're a younger lawyer, you're being careful. Now I'm thinking about the fact, I represent my client. I have to put my best foot forward, even if the risk is that a judge is going to be annoyed or say, I don't want to hear that. At the end of the day, I have to have put my foot forward. And if the judge says no, or I disagree, or, get out, I still have that responsibility. And of course, you have to do that professionally. But when you think about the solutions here for the challenges, some of these solutions don't just apply to lawyers. They apply to our obligations as lawyers and as technologists to educate everybody in the scope. So, right, there are all sorts of participants when we think about litigation and e-discovery. And that includes the judges, that we have to have some education. It's not unusual now for me, if I'm going to put a submission in, even if it's just a letter giving a sense of where are we, it's not even a dispute, I might throw a couple of sentences in there about TAR. We're looking at the application of technology-assisted review. I might put a footnote with a site. Here's where you can learn about it, just in case I know that the judge really hasn't had much experience. Making sure that judges understand the kinds of costs that are associated with discovery and that there are solutions out there, sort of giving a preview on that before we get to the dispute if one arises. The fact that more often than not, these types of tasks are going to be outsourced through a company like ours. And the fact that manual review is much less reliable. Judge Chinlin and I have both talked about a little bit of the generation gap. There are still people out there who, believe that manual review is the way to go. There are studies that tell you that's not true and it's not reliable, but in addition, there just is not enough time. There's not enough time to get through all that. So, and then finally, transparency, which to me does go hand in hand with how you work with your adversary, but also how do you work with your judge. The more that I can tell the judge about what reality is for us, what are the practical things that are happening in the case every day, the better I believe I'll fare, because I believe that I've garnered some credibility. And that works both in the context of my being a litigator as well as in the context of being a service provider.
Yeah, Ariana talked to you a little bit about how she evolved as a lawyer. I think the judiciary also evolved with their understanding of TAR. I think at first they thought it was too expensive and it was elite, and we shouldn't get involved in ordering it because it's only for the big mega case, and it's very expensive, and there's nothing wrong with manual review. I think now those who are a little more sophisticated in the judiciary say, actually it's cheaper and it's more efficient and it's faster, and so I should come down in favor of it if there's a dispute, because I don't want this thing to drag out. The manual review is going to take twice as long, and at the end of the day, it's probably less efficient, less accurate, and more expensive. So I think the judicial view has evolved over time, too. Much more supportive now of technology than it was.
Well, and again, coming back to Paul's example, so Paul has been working on a number of cases where he's not only being brought to the meet and confer, which of course means that great strides are being made much more quickly, but also being asked to come to court and to stand up and start talking. I can remember at the time that I was appearing before Judge Chinlin in the early 2000s, where the thought of bringing a technologist was absolutely just, the other side in my cases, they just wouldn't even do it because the fear was that the technologist would say something, either that was dangerous for the case, or, this is worse, that the lawyer didn't understand. So here the technologist is saying something, and if the lawyer doesn't understand it, the lawyer is really sweating, right? But the truth of the matter is now, as lawyers, you're so much better served if you have issues, especially about TAR, analytics, to have somebody who not only understands those issues, but has the ability to translate them into just regular human speak.
Yeah, plain English. It's really true. if you talk in technical terms, people don't understand you. People like me don't understand you. And you may not always appreciate that because you understand it, but your audience doesn't. So you have to have that ability to speak to people who are not on your level. And that's hard.
So we've gone through
Yep.
almost over half our time, and we're on
That's good.
slide 1.
Yes.
No.
No,
Well,
I know, we're
we'll
good,
have to our
though.
little
We're good.
examples. Yeah, we're
I'm
good.
watching the time.
Yeah.
Okay, so we thought we would do just some interesting case studies so that you couldn't nap, even
No,
though you
they're-
might still be tired. So this is a case study, and again, just to sort of have us interactive, but also feel free to raise your hands if you have questions. So our first study is, you have a requesting party that challenges a production of unusually low volume in a large pharma case. So this is not unusual. Large pharma cases, everybody expects that there's going to be a lot of data. So why wouldn't there be a lot of data? And the requesting party has that automatic jerk. There must be something wrong because there's too little. The producing party discloses that it has used key terms and tar. So lights should be going off for you. I'm not going to tell you which lights at the moment. So it's done that independently. Requesting party seeks detail about the key terms in TAR protocol, including the QC methods. So again, that search effort was done by the producing party completely independently of any kind of agreement from the requesting party. And I already like some of the facial expressions that I'm getting. That's good. Receiving party claims attorney work product privilege protections and refuses to share details. So, and I think that should be producing party.
Yeah, it should be
Yeah,
producing.
yeah.
Yeah, sorry, we had corrected the slide. So anyway, it should be producing party claims attorney work product privilege protections and refuses to share details. And so, this is the case study. We just want to talk a little bit about what are the details in terms of how this went down, how should it have gone down, and then engage the judge quickly.
Well, I've been told.
No, so Judge, when someone brings something like this to you, right, what are your initial thoughts about ordering disclosure of a process that the producing party is going to say, we did our obligation under the federal rules, we did a diligent search, and we're not obligated to disclose anything, and it's just not that many docs there.
I think a judge would try to get the producing party to give some detail as to what it did. It can't just hide behind a veil. So in this hypothetical, they did a keyword search culling first and then switched to TAR, and that's what made the data set so much smaller. And there's a lot of cases on this. Actually, it's become a hot topic whether you can, I think one judge called it, can you change horses in midstream? Can you start with keyword culling and then switch to TAR? And the case law has gone both ways. Some judges have said, no, you can't. You've got to go back on a do-over and use TAR from the beginning and not reduce it with the keyword searching. And some have said that was a perfectly reasonable thing to do. It saved costs, it reduced the data set in a decent way, and I'm not going to look further. But what most courts have said, to combine those two views, is if you're willing to be transparent, and I'm not going to order you to, but if you are willing, and I'm encouraging you, that will give you more credibility with me in deciding whether there's going to be a do-over and whether I'm going to criticize what you did. So the courts are, at least, if they're not ordering it, they're encouraging conversation, some disclosure. Tell the other side. In fact, better yet, work with the other side on the keywords. If you're going to do a keyword culling first, try to get together on what those terms are going to be. In one of the cases I read, the producing party used the terms requested by the requesting party, period. They said, we'll do your terms. You give us the list of terms you want us to use to cut the data set, we'll do it. And then we're going to use TAR. So there it was hard to criticize once they agreed to use the terms requested by the requesting party. But at least if you don't want to do that, you can at least try to work together if you're going to start with keyword culling. So I think the courts want to see cooperation, they want to see disclosure, they want to see people trying to negotiate, but I don't think they're going to order full transparency and say, show us the what do you call it, the seed set, show, disclose the documents that you use to train your tool. They're not going to order that. That's been my experience. But they are going to encourage a lot of cooperation and disclosure voluntarily.
So there's a lot to unpack there, right? Because you have the fact that there were search terms used and then TAR. So as we know, under Cal 1.0, oftentimes the initial seed set is being crafted by the use of search terms to try to find some good documents and start educating the machine, if you will. But of course now, as the technology has evolved, that's not necessarily the approach that's happening. So that's one thing to bear in mind. Another thing to bear in mind is that I can't imagine a case today for me where if keywords are being used where I'm not involved in that process.
Was you as a requesting party?
Yeah.
Yeah.
I take the position, if you use search terms and you do so unilaterally, you have done so at your peril.
That's right.
And if I find one problem, I am going to say to the judge, I asked you again. I had a rule, I grew up in a house, my father, 3 strikes you're out, we were a baseball family. Go Mets.
It's seasonal,
Yeah.
though. Yeah.
So we got to a point where I just said, you know what, why wouldn't you want to engage me in that process so that at least you can say, well, she signed off.
Yeah.
And then the other thing too is, to the extent that there have been some cases where the producing party has said to the requesting party, give me your search terms and I'll just use those, I say, no. Because the producing party knows information about its data set, whether it's the technologists that they're using or more significantly, the lawyers, including in-house folks. Well, who are the key custodians? I think about my great examples, because they're just easy, are merger and transaction cases, right? Acquisition cases. Well, the folks who are working on those transactions don't have documents and emails all over saying, oh, this company is merging with this company, and having that sort of out in the ether, because of course that could affect the stock price. So there are code words used all the time. It's Project X, it's Project Adelphi, whatever it is. And so those are the kinds of terms that the producing party knows by virtue of knowing its client, and I couldn't possibly know that because the whole reason the code was being used was to keep it out from the public. So I always use those kinds of examples, especially if I'm getting pushback. I expect that the common parlance that's being used by the producing party will be included in that effort. And if I don't get agreement on that, I'm actually going to take it to the judge. I'm not going to be, guns a-blazing, but I'm going to say to the court, we have an issue here, it's percolating, I'm concerned about where this is going, and I would rather we just get it all out in the open so that it's not having to look at it from the back end.
That's right. So what you're saying is, you don't want them to just use your terms
No.
because that's under-inclusive, but you do want input. Do you want to give them some terms that you want used, and then you want them to also supplement with the terms that should be used for that search, but you don't want to be excluded from the process.
Correct.
Right.
Really the way the process is working much more today now is with, we say to the producing party, give us your set of terms. What are the terms that you would use? And then we look at them and we finesse them, and then we get into a meet and confer. Could take a week. I have a very, very large data breach case right now. It's taken a long time. But I feel good about where we're going with that. And the truth of the matter is, when you engage the other side in these kinds of conversations about search technology, and particularly when you start getting into TAR, you actually gain sort of this, if you do it well, I think, and do it gracefully, you gain a good relationship with your adversary. And so to me, it interfaces very nicely with how the federal rules were amended in 2015. This expectation of, cooperation can be very, very helpful because cooperation and transparency save money. It actually interfaces directly with Rule 1 and what the expectations of that are.
So let me ask you a question as a requesting party. Some of the cases are the requesting party is very critical of the producing party having used keyword searching first to cull the data set. What do you feel about that? Do you feel that you should just use a TAR-type tool from beginning to end? as opposed to starting with a Boolean type search with keywords and then switching to tar with the reduced set? Are you opposed to that two-pronged system?
Sometimes I don't really have a choice about whether I have a problem with it, because again, the producing party has its own budgetary issues about whether they're going to go straight to a full tar 2.0 or Cal tool versus doing this sort of bilateral approach. But certainly, even if they were to use search terms early on before moving into tar, I expect that they're going to share what those terms were, because that then has become the baseline before we've even really gotten into the actual universe of documents.
But the criticism I've seen from the requesting party is that since the science tells us that that method of searching is not as accurate, they're worried that a percentage of documents has now been excluded and will not be searched with a tar-type tool because it was excluded in the keyword search stage. And they're saying that's why you should have used a tar search from the beginning and not reduced your set by 80%, because now you're not searching the 80% at all. Wouldn't you have been better taking the 100% and doing it right? So that's what the cases, I'm not in this field, but that's what the cases seem to point out as the problem in doing it in those two stages.
And we agree with that statement, but the transparency on the QC for us is probably the most important step of the transparency we ask for. So on the tar or on the search term side, if you do a proper QC on that left behind set, the null set,
right.
we can gain some comfort that we're not leaving behind important documents.
So what you're saying is if you do a test of the null set and it actually starts to reveal some relevant material, then the cut was not done right.
Correct.
Uh-huh.
But and if we just are looking for comfort, right, in the whole transparency aspect, we're shortcutting the system, right? We're not reviewing every single document anymore. So we're just asking for comfort that what you're doing is getting the relevant documents in a reasonable way. We don't want you to have to review every document because it doesn't make sense and it's not efficient, it doesn't save money. But just give us comfort that what you have done is protecting our interest as well,
Well,
and our rights.
why not just start with the 100% data set and use your tools to do the cutting and reviewing right there? Why have that first step?
It's
of
monetary. It's always monetary. So if you have 2 terabytes, go ahead.
Yeah, I mean, to the judge's point, first of all, isn't the standard reasonableness
Sure.
not perfection?
Yes.
Yes.
And,
Yes.
And when you're, for example, dealing with a corporation that has a file server that's petabytes or many, many terabytes in size, and only a small subset of that is relevant to the litigation, you can actually undermine the effectiveness of a tar tool by trying to apply tar to 100% of the data set because the richness level will be very low. So in that type of situation, when first trying to kind of get a subset of maybe the part of the file share that's relevant to the litigation is what you start with as opposed to the entire file share.
And there was another comment, yeah.
The answer is yes.
Yes.
I'm just a little curious about one item that, for me, being a tech person, that is never really discussed that often, which is really the realm of, okay, we have terms, right? But we have a lot of words. How come we're not showing dictionaries? Because those indexes have dictionary terms. Those terms have an importance, co-occurrence, how often they're in there, right? That leads to a different discussion. Often don't see that part. You point them to the dictionary, you have access to the dictionary, you know the words are there. The words are coming from somewhere, but they're not the dictionary. So how come that discourse should be part of the meeting, part of the discussion, presentation up front? That seems, as a tech person, seems like the first step.
And that's why they don't want you in court.
Exactly.
Because it's a very valid point, but I can't imagine a producing party disclosing or giving access to that kind of information because it's so vast and so unknown to them. They're not going through dictionaries to look for terms and co-occurrence and stuff like that. But it's an excellent point. I think we should work it in.
I'm looking forward to asking for that.
And in response to the first comment, the gentleman up front, this 100% data set that I was talking about was post-collection, so it's not everything in the company. You've already identified the custodians from whom you're collecting or the departments from whom you're collecting, so it's not as if to say every document ever created by General Motors. I mean, there already has been, hopefully, a targeted collection. So that full set is not as large as you made it sound, I hope. Okay, if you knew what you were doing on the collection side, okay.
But that actually does depend on who the lawyers are in terms of, being on opposite sides of the V. For any case that I'm in, I and my team are going to be engaging the other side in a pretty drilled down conversation. You have a lot of lawyers out there who, they don't understand anything of what we're talking about even today, and a lot of what we're talking about today is fairly basic,
Yeah.
right, for you in the room. But these lawyers have not been exposed to TAR. They've not been, even if you're dealing with search terms, those are things that scare them because they feel like they're definitely going to be hoodwinked. So if they think they're going to be hoodwinked with search terms, they definitely think they're going to be hoodwinked with TAR because they don't know what TAR is.
Well, I think your point about reasonable, not perfect is very important there, because sure, you're not going to find every single grain of sand, but you don't need to. You're going to find most of what you need for the case, but which probably takes us to case study two.
Yes.
Because now
Yes.
we are running low of time, and we have
I'm
three
very-
more good case
I'm
studies.
very good about time,
Yes,
so
you are.
don't worry about that.
You are very good about time.
Okay, so case study number 2, challenging a production. So we have a situation where the requesting party in a large, complex case receives 5 million documents. Guess what? Towards the end of discovery, we're weeks away. Sometimes we're actually days away from the close of discovery.
Sometimes
And-
days after.
And, right, sometimes days after, right. It's suddenly, there's a weekend, and everybody thinks you're done, and on Monday, this huge production shows up. So the requesting party, this is very important, the requesting party used TAR to categorize the documents in an attempt to triage the review, and discovered that 75% of the production was actually non-responsive to the document requests. Now, before I say anything more for the rest, I just want you to remember what I said, which people lose sight of. When you're a plaintiff's lawyer, especially in asymmetrical cases, it's contingent work, you're advancing the cost. You all know when you get a production of volume, well, what are the costs associated with volume to host it? You're paying by volume, right? And so the last thing you want is to have to put something on a platform that you're never going to use, but you have to pay for. Requesting party moves for sanctions relating to the lack of responsiveness to recover the costs incurred to apply TAR and the associated billable hours wasted. I would have added one more thing here, and I'm sorry I didn't see it before, but I would have said also the cost to host the non-responsive data, to throw it up on the platform. Producing party challenges the 75% number complaint and the use of TAR to make the assertion. So, I'm supposed to play the role of the producing party. And I have been a producing party in the past. I do some commercial litigation with some pretty big wigs on either side. But so what's my position? My position is I have no idea what tool you used. I know what tools I use. I have no idea as to the reliability. You are basically utilizing the benefit of just saying you got a lot of stuff that you don't think makes sense, but meanwhile, your document requests were so broad, requesting party, that I had no choice but to kind of go in and give you the gamut so that we don't have to fight that I didn't give you the responsive stuff. The responsive stuff is in there. You may not think the other stuff is responsive, but that's not my issue. I carried out my responsibilities, and I did something that was more than reasonable. The volume shows you that.
And they also, the defense side would also try and introduce a little doubt into the accuracy of how the tool was used, right? So we see a lot of time the requesting party challenging a seed set, but we also see the producing party, when these kind of arguments are made, challenging how the seed set was made. Really, did you include the right documents in there to determine responsiveness? Because it's responsive can be on a scale, right? And so when we would set up a system like this on a requesting or on a received production, we scale the documents. They're not responsive or not, right? Because hopefully they're all responsive, and they're not privileged or not because they hopefully are not privileged. So we have to put them on a scale, and then we throw the predictive coding tool at it and scale the documents. And so what we're saying here is all of the documents were at the wrong end of the scale. They were on the non-responsive part of that scale.
Well, yeah, I think that Ariana did a made a valiant effort to make the case for the producing party, but you probably are going to lose in front of me. And the reason,
Great.
well, I'll tell you, I know you wanted to lose. And the reason why, though, is I'm skeptical about these facts. This sounds like a classic document dump of burying the responsive stuff somewhere in the 5 million. According to the facts here, the 5 million is a big number. It's too big. And it's late. It's coming at the very end of discovery. So it already sounds to me like somebody's trying to bury you and bury the responsive material. And then you have this claim that most of it is actually non-responsive. 75% of it is basically junk, and it was dumped on you at the last minute. So if you can substantiate that at all for me with examples, that's all it would take. You would have to say, I can do a random sample, Judge, and show you. I'll show you actual documents. They gave me this. It's got nothing to do with the case. They gave me this. By the time you show me 10 of those, you win. I mean, not you, but you in your real life would probably win, because I would say, 5 million last week, and you've already shown me all this non-responsive. I'm going to order a do-over, and there's going to be cost to that. And they're going to have to pay your cost for the tools. Now you're back in your role of requesting party. The cost that you had to spend looking at a set that wasn't responsive. And I think that when a producing party is slapped down once or twice like that, they won't play that game again, because it's not a good game to play. It's not honest. So there's something about the way the facts are laid out here. Of course, it's done for teaching purposes, but it would make a sharp judge, I think, skeptical. So that's where I come out on this one.
Well, and there's a lot of education to be offered to a judge to make sure that the judge really understands what we're talking about. But
Yes, yeah.
Paul and I actually had a case where the producing party told us that they were going to use search terms, even though I had said to them, I think this is a perfect case for TAR application. We'd be open to hearing what are your tools, what are you using. Very, very significant firm. They have e-discovery people. It's not like they're working in the dark ages. And they just insisted that they were going to do what they were going to do. And I said, you're working at your peril. I promise you, you don't want me as your adversary on this. And I said, and don't start producing anything until we've talked about what it is you've culled and what you're planning on producing. And instead, we got a data dump, and they just kept producing, right, on a rolling basis. And I did my 3 strikes you're out. I wrote 3 letters, and after the third, we went to the court. The court, actually, it was interesting. The adversary decided that upon our motion to compel, they would file a opposing motion for protective order. So imagine this poor judge. The judge ends up with not 1 pile of paper, but 2 piles of paper that basically say the same thing. Because I'm making my motion, they're opposing. They're making their motion, and I'm opposing, with the same facts in both sets of papers.
Oh, that's an inefficient judge. Any judge knows that the motion for protective order is merely a response to the motion to compel, and I would never have allowed 2 sets of briefings. So there it is. You got to know how to do the job. Just like you got to know your job. Judges have to be trained. It's 1 motion, 1 set of papers. I get it. The protective order is simply the answer to the
Well,
motion.
then
But
you
they're
really
to
would have
compel.
loved the 5-hour hearing.
Right,
Yeah,
right.
no.
So, and this is why I love this case. Paul and I were both in court together, and we were on our feet for 4 hours. Because so much of that was an education. The judge actually didn't know much about TAR.
Federal or state?
Federal.
Ah.
The judge did not know much about TAR, so we did an education. We gave very specific examples. We talked about the cost that the other side had purportedly expended and what we could show should have been expended, and we got a do-over. We actually did get
I'm
the
not
do-over.
surprised.
Okay, so just moving on.
We can skip this one. Let's go to the last one, because we
Sure.
have a couple minutes left.
Yeah.
Oh, we're skipping the antitrust case? We're
Yeah.
going to the
No,
end.
we're skipping
Oh.
the slide.
No antitrust. Okay.
So just the final thoughts I thought would make sense.
Yeah, well, we have a issue with our computer here, with the battery running low, so let's see if I can fix that.
I love when the lawyer handles technology.
There you are.
Okay.
Okay.
So, just some final thoughts about when to use TAR on an incoming production. And we do it all the time. That's actually part of our mantra and methodology for both what I do as a plaintiff's lawyer and also being at Meta-E. You know, the things you have to really think about are time, resources, costs, value of the case, and richness of the document population. And this comes back to that slide that we showed before, right, with the challenges and the solutions. These are the things that you constantly have to be thinking about. How do they interface? Sometimes you do have a producing party that is going to give you a data dump, and you're going to have to figure out what to do. But on an incoming production, what is the expanse of options? Am I able to look at all the options from, using one particular tool versus another, and at the end of the day, I'm going to make a decision about the best tool? Or am I actually going to be somewhat hampered in that that tool is too costly? The flip side is that tool may be costly, but does that tool take longer? Because if running that tool takes longer, the way that I'm looking at cost has to change, right? Because time is money. And so just because the TAR tool you want is the most expensive doesn't mean it's the wrong one to use if you don't think you have the budget. Because at the end of the day, if you choose the other tool, but it takes more time, that may actually put you in a situation where you're not going to get to goal. And again, cases have deadlines. So you often are up against the gun in order to complete discovery, complete depositions. You might have a motion for summary judgment where you need all of that information to have been reviewed to determine what's your best evidence. I'm sorry, we're seeming to have some kind of
Is it like when the hook
It's
comes
okay.
out and
Yeah,
pulls you off the
maybe.
stage?
We are literally at 9:29. So I'll just put it out there. Does anybody have any questions?
Well, I wanted to add one more thought.
Yes.
Which is about Rule 1 of the Federal Rules of Civil Procedure, which talks about the just, speedy, and inexpensive determination of every action. And that means it's a balancing test. That's what those three words mean. And really, today, they could add proportionality. So is it all proportional to what that case requires? But the words are there. You want justice. You want it to be speedy, because justice delayed is justice denied, of course. And you do, the word inexpensive simply means you take cost into account. And I totally agree with you. Sometimes you spend more money in one way to get a result faster, which saves money in another way and gets to the end of the case quicker. So I think judges are sophisticated about that. And while when we revised Rule 1, we didn't require cooperation, it's right in the notes to Rule 1. It encourages the parties to work together. So if the whole point of takeaway of this panel is if people talk to each other and cooperate and figure out that the requesting party and the receiving party have to get together, it'll work out in the end of the day to be just, speedy, and inexpensive, and it will definitely involve technology for the many of you here who are on the technical side. So
Well,
that's my closing statement.
No, and that actually is the perfect close, because that's what I was going to say. TAR has really changed the game in a very positive way, not only because of the way we practice, but it really does interface in Rule 1 so neatly and perfectly. It's a solution that's come at just the right time when we really need it. So thank you so much for coming.
Yep, thank you very much.